My name is Thomas Allen, and thanks for joining our new video series in international disputes that I'm calling Issue Spotting. We're going to take some shorter looks at some of the important topics in international arbitration today. And we're going to start with the new ICC rules that are becoming effective in January 2021. And in particular, one of the more controversial rules, and that is the requirement that third-party funding now be disclosed. Let's take a close look at that rule. The rule is found in Article 11.7, and it requires each party to promptly inform the Secretariat, the Arbitral Tribunal, and the other parties of the existence and identity of any non-party which has entered into an arrangement for the funding of claims or defenses, and under which it has an economic interest in the outcome of the arbitration. So this rule is designed to assist arbitrators and prospective arbitrators in identifying potential conflicts of interest with the third-party funders. The issue I would like to pose is whether the goal of identifying conflicts intrudes into an area that is potentially prejudicial to the party that has secured the funding. My concern is that the party that has obtained funding will be viewed as having nothing at risk in the arbitration, and that this could result in an unconscious bias toward the claimant that has secured the funding. We also have the mechanisms available where law firms can effectively be the client for funding purposes and can essentially obtain funding based on a portfolio of claims that the law firm might have representing a variety of different clients. To the client, this arrangement may appear no different than a contingency fee case where the law firm is accepting the risk that no recovery will be made and the risk that the lawyers won't be paid. The difference is that funding is typically non-recourse, so the loss would not hit the lawyer but be shifted to the third-party funder. Other questions are also raised for me by this rule. For instance, would a parent company funding litigation for a subsidiary need to disclose this fact? Under the terms of the rule, they may. If a respondent has insurance proceeds from which any award will be paid, should this also be disclosed under the same maxim that the insurer has a stake in the outcome of the proceedings? The point here is really not to resolve these issues today, but to identify them and to try to further the dialogue around them. Great care does go into formulating these revised rules, but they remain theoretical until parties start to apply them. In this way, the strengths and weaknesses of these provisions have really yet to be tested. So in reality, I'd say that I'm agnostic about how this rule will work in practice. However, I do at least have some initial concerns that in working to solve conflicts, issues of prejudice to the claimant may have unwittingly arisen.